Um, all right. Well, what I was hoping to talk about today is resolving your differences with your former employer. Now, for some of you, this will not be an issue, but for many people, when they leave their employment, it's a difficult time. It can be a time of conflict. Sometimes in employment practice, we distinguish between good leavers from their employment and bad leavers. A good leaver might be entitled to receive certain benefits when they leave, but if the employer determines them to be a bad leaver, they may not receive those entitlements. So that has a particular meaning when it comes to things such as equity and shares. But I want to ask a bigger question, and that is that what can you do to make sure that you leave your employer on good terms, and that once you've left, you stay on good terms with your old employer? Because I think that's an important thing. But a quick case study. I was looking at the Australian Financial Review this morning, and there's an article about Jane Herdlicker, who's now the Chief Executive Officer of Virgin Airlines. Previously, she was the CEO at A2 Milk. And it's interesting, although she's left A2 Milk some time ago, there's now a bit of a public dispute between her and her old employer. The evidence is that she was asked by the board of A2 Milk to leave, but now she's been making public statements to try and suggest that it was her own decision and that there wasn't a problem with her. That's not me to pass personal judgment on her or her circumstances, but it's just interesting to note that that's become a public dispute, and that perhaps doesn't reflect well on either party. On the other hand, I've always tracked with interest the career of Mark Scott, who was previously the Chief Executive Officer of ABC, the Broadcasting Corporation. And back when he left the ABC, he made a public announcement, and no doubt with the approval of the board, that he would be leaving in a few months' time. He made sure that there was an orderly handover of his role. It was clear that he was leaving in good circumstances and with his reputation intact. Now, of course, sometimes you get to choose when you leave your job. You can tender your resignation, and perhaps you can leave on your own terms and with a nice farewell from your employer. Other times, it may be that the employer has made the decision to terminate your employment. That might be because of a range of circumstances. It might be due to redundancy. That's pretty common, and many people suffer that a number of times during their career. Other times it might be because of performance or conduct concerns, or misunderstandings or disputes of some nature. And when that happens, it may be that you've got less control over the circumstances of leaving and what happens. And sometimes when you do leave, that leads to a dispute. And I represent both employers and employees. When I represent employees in employment disputes, I notice the personal stress that a dispute puts upon them. And it's not just that, of course. There's risk for them in terms of their financial situation, but also in terms of their career prospects. So there's often a lot at stake for the employee when there is an employment dispute, particularly a termination dispute. It's not a great outcome for the business or the organisation either, though, because it can cause them legal and financial and reputational risk as well. So some of the things that become the cause for a dispute around the time of termination can include whether the employer has terminated the employment for a fair reason or in a fair way, or maybe they've terminated for an unlawful reason. So that can sometimes be a cause of argument. There may also be an argument about what the employee is owed when they leave. How much notice for termination should they be given? How much redundancy pay? What are they owed in terms of annual leave or long service leave? What about incentive remuneration, such as bonuses or equity, etc.? Another cause for dispute can be, well, what are the employee's obligations that are owed to an employee after they leave the employment? For example, is there a term in the employment agreement that prevents the employee from working with a competitor for a period of time, or perhaps from attempting to solicit or entice away the clients or even other employees of the employer? And obviously both sides, both the employee and the employer, may have significant concern with their reputation in the event that the dispute becomes more broadly known. But as for you, what's important for you when you're leaving a job? So there could be a range of things. For some people, the financial outcome is critical because it may be that they're in a challenging financial situation. They need to support their family. It may be that that's of lesser concern. It may be that what's more important is being able to move forward and get that next job. Many people want to try and leave on good terms. They want to leave with their reputation intact. That could be important. For other people, sometimes emotions run strong. Sometimes there's a lot of hurt that's caused by decisions made by an employer, and there may be a feeling of wanting to get some revenge or being proven right about the circumstances of their employment. And yet other people have other reasons or other things that are important for them, I should say, when they're leaving their employer. Well, but the fact is that disputes arise. And those disputes can arise during the employment, they can arise upon and following term. But it's fair to say that the sooner you can resolve a dispute, the better. And so the best approach is always to try and resolve the dispute directly with your employer, if you can. I always think that's the first best thing to do, is to try and negotiate directly with the employer. Now, sometimes you can do that yourself, and that might work well, especially if there's still a high degree of trust between you and your employer. Other times you might need some assistance. You might need a professional advisor, such as a lawyer, or a trusted and knowledgeable friend who can assist you. If direct negotiation doesn't work, sometimes it might be useful to have a third party involved to assist with the resolution of the dispute. So in employment and industrial law practice, it's very common to have what we call conciliations or mediations, and that's where a third party comes in. They don't have any obligation or connection with either party, and what they try and do is encourage the parties to reach an agreement. But of course, sometimes, despite your best endeavours, you may not be able to reach an agreement. It may be that one or other party is not prepared to compromise, or it may be that the thing that's really important to one party, the other party is not yielding to. So sometimes litigation becomes an option. For a dismissed employee or an employee challenging a decision of their employer, it needs to be said that that can be costly, it can be stressful, it can be risky, and the risks are not just financial, they're significant reputational risks too. If an employee fails in their litigation against an employer, typically that results in a public judgment that anyone on the internet can now read, and that may reflect poorly on the employee. Equally, on the other hand, the employer has a lot to lose in that scenario too, particularly from a reputational perspective. If there's a public judgment, for example, that the employer dealt with an employee unfairly or unlawfully, that will not be good for them or their business. Well, I think a really important thing though, in ensuring that you can resolve any differences that you have with your former employer is firstly being aware of what the duties are that you owe your employer. or your former employer. And sometimes you may be unclear about what those duties are, and it might be important to inform yourself, perhaps to get advice. But it's worth noting that under the law in Australia, once an employee has ceased to be an employee of their employer, there can still be some residual duties that the employee owes. For example, even if there's no written employment agreement, a former employee will still owe a duty of confidence to their former employer. That means that they must not misuse any information which was given to them during their employment in which an expectation arose that they would keep that information confidential. But of course, most employees these days have written employment agreements, and often the employment agreement will spell out obligations that the employee will continue to owe the employer even after the termination of their employment. So for example, the employment agreement might say that the employee must protect and not misuse the confidential information of their former employer. And that's typically an obligation that continues forever. Also, the employment agreement will probably say, or might say, that the employee must not use the intellectual property of their former employer. As I mentioned earlier, some employment agreements, particularly for persons in more senior roles or persons in client-facing roles, may put certain restrictions on an employee after they leave their employment. And these types of restrictions I'm talking about are sometimes called restraints of trade because they restrain the employee from doing certain things. Now, here in New South Wales, the law is a little bit different to in other states of Australia. It's interesting that in my professional practice, I've found that there are two big misunderstandings about restraints of trade and how the law applies. There are many people who will tell you that restraints of trade are not worth the paper they're written on, that they can't be legally enforced. There are other people who will tell you, well, if it's in the employment agreement and if you signed the restraint of trade and you agreed to it, you should be bound to the letter of the restraint. Well, in fact, the truth is often, or typically somewhere in between. In New South Wales, at least, restraints of trade are valid and enforceable so long as they go no further than is necessary to protect the legitimate interests of the employer. So those legitimate interests might include, for example, the fact that the employer may have a legitimate interest in protecting the relationships that it has with its clients or customers. It might have an interest in protecting its confidential information and intellectual property. It might have an interest in protecting the employment relationships that it has with its staff. They're all legitimate interests that the courts recognise. And so for that reason, it may be that the employer has agreed with the employee that for a period of time following the employment, the employee may not work for a competitor or may not solicit or entice away the clients or customers of the employer, or may not even try and encourage other employees to leave the employer's organisation. Some restraints might also state that the employee is prohibited from making any disparaging or adverse remarks about their former employer to other persons. Now, so as I said, there are these two sort of competing misunderstandings about restraints. And so if you do have a restraint of trade in your employment agreement and you've left your employer or you're contemplating leaving your employer, it would be good for you to understand what those obligations are and to respect them. Because obviously, in terms of being a good leaver, in terms of resolving any differences you have with your employer, think about what's important from the employer's perspective, that's wanting to protect their organisation. Now, of course, it might be that the employer has attempted to go too far in protecting those interests, or is not being fair with you, or is not being lawful in terms of what they owe you. And my view is that it's right for you to investigate your position and perhaps agitate your position with your employer. But you want to do that in a way that I think gives you the best prospect of leaving on good terms, and also ensuring that you can move on to your next role, which is for many people perhaps the most important thing. So my tips for resolving your differences with your former employer and moving on and being a good leaver, I think, are to respect your obligations that you owe to your employer. In any dispute, be prepared to engage in reasonable compromise. As a general rule, you're better off trying to reach an agreement early on a confidential basis rather than having a dispute drag out, which is not good for you, not good for you personally or financially. Sometimes, though, that's unavoidable. Sometimes it can't be helped. Often what happens when an employee does leave, but when they manage to reach an agreement with their employer, is it's quite typical for the employer and the employee to enter into a new written agreement. Sometimes that's by way of a legal instrument called a deed. A deed is just a special type of contract. And in that deed, the employer and the employee may agree that now that the employee has left, the employer will make an agreed payment to the employee. And moving forward, both parties might agree, for example, to keep the dispute confidential, not to make any disparaging or unkind remarks about each other so as to protect each other's reputations. And they may agree on other things as well. So there's much to be said for doing that if it's possible. I always think that honesty is the best policy. To be a good and honourable employee and servant, your employer demands honesty from you, and that's the right thing to do, isn't it? And I think that that same principle applies when you come to resolve disputes and differences with an employer. Some 2,000 years ago, the Apostle Paul wrote some advice to a church in Rome, I should say. And he said, if it's possible, as far as it depends on you, live at peace with everyone. I think that's wonderful advice. I often think about that when I'm trying to assist my clients to resolve disputes, because it goes to show that sometimes there's only so much you can do to resolve differences with other parties and to live at peace with them. But nonetheless, that's a good and worthy goal. Well, Peter, they were the main things I wanted to cover, and that might precipitate some questions. And I'm very, very happy to answer any questions that anybody has.
Thank you very much, Adrian. I should say that I did start the recording of this, so if that's not appropriate, easy to wipe it off. And with respect to others, if there's anything confidential, anything wants to share, then we can also, of course, delete that from the recording. So don't be perturbed by that. So let's go now to a general time of your timing. Perfect, Adrian, to a general time of Q&A and discussion. So at this point, I'll hand it over to everyone. So just unmute yourself and feel free to ask Adrian your question.
Put up your hand or speak if you...
Yeah. Hi, Adrian, it's Anthony. Can you hear me? Look, thank you for your presentation. I think you're back on mute, but my question is, if you're unsure of your obligations, should you ask that of your employer in your notice of termination? If you're issuing a formal notice of termination, or resignation, should you say on the bottom, can you kindly advise what my obligations are beyond termination or the likes?
Okay, that's a great question. Yes, I guess you could. I would suggest that a prudent thing to do would be to carefully review your own employment agreement before you give your resignation. The sorts of things that you want to look out for are simple things such as, number one, how much notice are you required to give? Number two, presumably you need to give it in writing. Normally, you don't need to give a reason for your resignation, but on a personal level, you may want to. You don't need to expressly affirm the obligations that you're under the employment agreement employer when you resign. In a sense, that really goes without saying, because you and the employer have already agreed on the employment agreement that should generally contain all the important obligations. But because of the complexity of some of these issues, particularly those restraints of trade issues, it can be a good idea to get advice about that. If you think that there's any doubt, if you think that there's any possibility that by accepting employment with a new employer, that it might put you even arguably in breach of those post-termination restraints, I'd recommend you get advice about that, because you don't want to do something that might put you in breach and put you in a position of legal risk. Quite often, you see, if there is a concern or possibility that you might be in breach, it's something you can often talk through with your current employer, and to get their agreement that what you'd be doing as you move forward would not be a problem.
Right, thank you for that.
Other questions?
Adrian, I've got one.
Okay.
If there is a non-compete, for, let's say, I don't know, I'm making this up entirely, like 6 months or something, so you can't go and work for a competitor, but that's all you know how to do because you've been doing it for 30 years. Does the employer have to pay you for those 6 months, or can they avoid paying you and stop you from working at the same time?
Yeah, great question. So let's assume that it is a valid restraint that stops you from working for a competitor for 6 months. The employer is only obliged to make a payment to you for being, effectively maybe unemployed in that period, if the employment agreement expressly requires them to do that. Otherwise, they're not obliged to make a payment. The law generally recognises that when you enter into an employment agreement, there is an exchange of valuable promises made. The employee agrees to perform work for the employer, and the employer agrees to pay remuneration to the employee. And that employer promise to pay remuneration is also generally considered to be consideration, something of value, for which the employee becomes bound to the restraint. Now, but what I would say is this, is that there are many employment agreements that do have those non-compete restraints, and often they go further than is necessary to protect the interests of the employer. For example, let's say, Cock, that the employment agreement also says that you must not solicit the clients or customers of the employer. It may be that if you keep to that promise, that's adequate to protect the employer's interests, or it may be that it's not. So sometimes it's worth having a negotiation about that. But to come back and answer your question, no, the employer doesn't need to make an additional payment for the restraint unless the employment agreement expressly says that.
Okay.
Adrian, can I just ask for your view on exit interviews?
Yeah, so many employers, of course, will want to hold an exit interview with their employee, and depending upon the circumstances, the employee may be able to decline the offer or request to participate in an exit interview, or they may choose to anyway. Now, of course, many employees will fire a salvo on the door on the way out the door, and tell the employer what they really think in a sort of a no holds barred approach. I think this gets back to what I said on the last slide there, that I think there's a place for an employee to be honest and candid, but also respectful at an exit interview. If they're leaving because they were unhappy, I don't think that's necessarily a bad thing for them to tell the employer. But I could also understand an employee wanting to be reserved about that, particularly if they are looking to preserve the goodwill in the relationship as they move forward.
May I just make an observation, Adrian? We are career coaches. Sometimes we're at the other end of advising a client that has left and for whatever reason has given a fairly vindictive exit interview. They feel good about it. They've got it off their chest. But my advice is don't give exit interviews except saying thank you. I mean, your point about the employer having a responsibility to the employee. I left under very challenging circumstances when I was made redundant. And they gave me opportunity for an exit interviews. And I said, well, thank you very much. You've looked after me well for 4 years and you've paid me out. I said, what else do you want to say? And then they really wanted me to bring up all the points that was a great concern, and I just declined. No, the point that I want to make is that the last entry on my file was okay. And the point that we're making is that many of our clients, the last entry on their file would be, well, he said this, this, and this, or she said this, this, and this, and that's why we got rid of them. So it's almost endorsing their firing of the candidate. And we don't have too many, but we do have some situations where it's very difficult for the next employer to say, well, can we go back to your previous employer for a reference? And that's what's on the file. That's the last page. So I'm just saying, I'm advising as a career coach, and I'm just asking your view, Adrian, be extremely careful. On my file, it all said, thank you. That's all I said.
Don't burn your bridges.
Don't burn your bridges. Yeah.
I think that's great advice, yeah.
Are there other comments or questions for Adrian?
Can I just ask a question just on that note about exit interviews? So that's usually with the HR department, right? Are your responses kept confidential, or are your previous, employers and bosses and managers able to look at those responses as well?
So any information, you're right. Firstly, it is an HR process typically, and I think that's probably half the problem, because respectfully, HR can be big on process and often lose sight of what the purpose of the process is. But any information that is gathered becomes a business record of the employer. And so they can use that information, they can share it internally however they see fit. So there's certainly no confidentiality between HR and the rest of the business or organisation. It's worth remembering, and I don't say this to try and create any sense of division, but it's worth remembering that human resources are ultimately the servants of the employer. They exist to protect the interests of the employer. They are not independent, neutral arbiters of disputes between employees and employers. Although they may sometimes try and be conciliatory, and that's good, they are not there to represent the employee's interests with respect. They are there to represent the employee's interests. The information that is gathered at an exit interview is information that relates to employment. It's probably not information that constitutes personal information within the meaning of the Privacy Act. And so if you authorised a prospective employer or recruiter to contact your former employer for a reference, your former employer would be at liberty to disclose the information that was gathered in an exit interview.
Adrian, could I say something? Yeah, great, fascinating conversation. In fact, one I've not really given a lot of thought to in the past about, exiting well. I was down at the War Memorial at the end of last year for a residency for 2 weeks, and my old boss in the military, who was quite senior, is now basically the number 2 at the War Memorial, and in effect, I resigned to that guy, and which was a pretty big deal at the time, and I was aware I hadn't done it, but there was an exit interview process within the military, which was basically just it was a redundant process. It left the employee feeling frustrated. So 14 years after I left, I had a chance to sit down with this guy again. And so we sat for about an hour and talked in his office with coffee. And that, in effect, was my exit interview of some sorts. And so the only comment I'd make is I fully endorse the comments that came before, but there is personal needs to be met from the employee. Back to what you're saying about the HR representing the employer's perspective, that while it might not be the sort of salient time to fire off a broadside as you're leaving, to deal with grievances and to deal with exit interview, to find professional counselling, maybe not through a lawyer but through some other appropriate avenue, I think is something I'm really taking away from this talk, that it's really important to put those things to bed, because I just found that conversation in Canberra so liberating in that regard.
That's really instructive. That's fascinating. And I think one thing that flows from that too, is that as you move forward, resolving your issues with your employer is just one part of it, isn't it? And some of that may be beyond your control, but there are also so many other supports out there, including this group, which I think is great. So yeah, that's the fuller picture.
Adrian, can I lead you into another question here? When I had a situation when I needed some advice from a lawyer, I went to this lawyer, I got some advice, but I didn't tell my employer. And his advice was, try and keep it out of the conversation. Because once you say, my lawyer says this, then they feel they have to get their lawyer, and that becomes an issue which is outside the control of two individuals. So although I went for advice, I didn't actually in that conversation say to my employer, my lawyer says, or I've been to a lawyer, because his advice was, things would start in a different forum. And it was actually good advice, because I never did tell them.
Yeah. Firstly, sorry about the dog in the background. I'll have to performance counsel that animal. So, I think it's a really good thing to get legal advice when you need to. But one of the things that I think, just reflecting on what you're saying there, if I understand you, is that it's really good to work out with the lawyer how you engage the lawyer. So the way that I like to explain it to my clients, when I'm acting for an employee and they've got a dispute with an employer, I say to them, look, I want to give you a range of options here. I want to give you a range of options, Daniel, and I'll paint these options on a spectrum from least confrontational through to most confrontational. And at the least confrontational end, it may be that all you're doing is coming to see me. I'm just privately advising you. I'm equipping you to understand your situation with your employer, and I'm equipping and enabling you to have that dialogue directly with your employer so you can negotiate that without lawyers being involved and without even mentioning that you've come to see me. The next degree of confrontation might be, though, to tell the employer that you've seen a lawyer so that the employer knows that you're moving from a position of knowledge. Or it might be that further along the confrontation spectrum, you engage the lawyer to communicate directly with the company, or perhaps even to just shadow write your communications with the employer. And then obviously at the most confrontational end of the spectrum is litigation and mediation and so forth. So it's worth thinking about that too, because, and I think a lot of people, when they're seeing a lawyer for the first time, perhaps don't realise that there's that range of options there. So try and think about, well, what's the best way of engaging a lawyer that's going to assist to resolve any disputes or concerns rather than inflaming the situation.
I have a question. So am I correct to say that it's often good to resolve disputes internally prior to going to a lawyer, because at the end of the day, on yourself, it will leave a mark, like for your future employer. Let's say for example, this particular nurse has brought the employer to a legal suit, for example, but they don't realize that for their future employment, somehow or other, I can do a check on this person, and if I know that this particular nurse has brought someone to a legal suit, I'd rather not hire this person just in case. So am I correct to say that it's sometimes better not to bring the employer in a legal suit, for that, if you know what I'm trying to say?
Yeah, I do. I think that's a great point. Certainly during your employment, disputes can arise. They can arise with colleagues, with managers, with the business. Most employers these days have a grievance resolution procedure, a policy document that you can follow, and that's always a good starting point. But you could also just get legal advice or professional assistance to help you as you, for example, articulate your dispute and follow that procedure. When it comes to termination of employment, though, that grievance procedure is typically not going to be available. Sometimes it will be, but typically it's not. And that's generally because the employment's ended or is about to end. So you can't follow the grievance procedure. But even so, it's again, I repeat what I said, is that if you are able to resolve the dispute early, and preferably resolve it directly with the employer, that's the best outcome for you.
Adrian, just following Ching's comment, it may border on the question of whether there are protections for whistleblowers. Is that a separate issue? Yeah.
So we now have whistleblowers legislation in Australia. Well, actually, it's existed in pockets of Australian community for a while now. But if for example, you become aware of wrongdoing within a company, particularly if it involves illegality or any other state of inappropriate affairs, you could become a whistleblower. And that's typically where you tell the employer or even a third party about the wrongdoing, and that whistleblower protection laws, I should say, confer protections on you. So, for example, it would be unlawful for the employer to dismiss you if you have become a whistleblower by bringing attention to wrongdoing. So they're fairly new laws, but yes, so it's really a fairly separate thing to what we're talking about here today as a rule. Yeah.
Although I guess the question is, would it offer protection against that information being divulged to a prospective future employer?
Yeah, it could. It certainly could. And in fact, there are serious penalties on employers that, for example, divulge the identity of a whistleblower unless any of the legal exceptions apply.
And does that law also protect the individual if they choose to leave the company and then they divulge that information? Does that act to protect them as well?
It will continue to protect them, and they could still have legal rights in relation to the fact that they were a whistleblower. But obviously the fact that they're no longer an employee means that there's certain action that like they can't be dismissed, obviously, because they've left, for example. So that would be one instance where the protections are a bit more limited.
But sorry to kind of go on and on about this, but I mean, so we mentioned before that there's that non-compete clause and all that as well. Does that kind of come into play if they do decide to become a whistleblower, and are they protected under that?
Yeah, no, the contractual obligations, such as under a restraint of trade, they're quite independent to activities such as whistleblower, so they can continue to apply.
Adrian, can I just ask, you mentioned earlier about obligations of an employee to their former employer that continues, such as confidentiality in relation to IP or other confidential information. What is that under? What sort of law is it under? Is there like a statute that covers that, or?
Yeah, in fact, the source of law, there are at least 3 sources of law, Cox. So number one, there might be contractual obligations of contract, and that's because the employment agreement might have expressed terms to protect confidential information. So that's number one. Number two, we have another body separate to the common law, which we call equity, and that has the rule of equitable duty of confidence, which is very similar to that contractual duty generally. And then thirdly, there are obligations under the Corporate Act. If you're an employee of a corporation, then the Corporations Act also imposes statutory duties on an employee or officer of a company not to misuse confidential information. Those obligations, those legal obligations are pretty clear and well known, and it's important to respect them. Sometimes, though, a question can arise about, well, what is the confidential information? So, for example, the former employer might say that its client list is confidential information. But the employee might say, well, look, this is a very well-known business. Everybody knows who the clients are. So there's nothing secret about that. So sometimes there can be an argument along those lines.
Thank you.
I think we've got time for 1 or 2 last quick questions before we go to our breakout groups. So perhaps from some that we haven't yet heard from, any comments or questions you'd like to raise?
Yeah, this is Socrates. Thanks, Adrian, for the talk. I guess this is sort of a question/comment. Under the guise of sometimes it's better to a good defense is a great is by thinking about sort of being offensive at times. And I know we've been talking about the tail end of the employment process, but how much work do you do? And I guess your opinion on the leverage that you can get by actually negotiating, paying attention to these things on the way in. I know it's always hard to talk about, exiting when you're just starting a new situation, but at least out of in personal experience, because of how attentive we were to those things at the beginning, it sort of mitigated some of the issues at the end, particularly with remuneration around non-compete periods, because anything can happen. There's a change in control, and suddenly, the new company just doesn't really care, and they're just going to manage to whatever the terms are. So there's no goodwill, potentially no goodwill there at that point that you would have been able to have at the beginning, recognizing that things can potentially change.
Yeah, that's a really good point, because of course, the contract is with the employer entity, and managers and owners can come and go. But although for example, most businesses are corporations, which is fictionally a separate legal entity. Well, in reality, a separate legal entity to a person. But ultimately, companies are run by people, and their attitude can change. So look, on the way in, well, I guess the thing to note is that in the majority of circumstances, a prospective employee or job candidate generally has limited leverage and negotiating power to make any significant changes to the employment agreement that's being offered, including with respect to post-termination restraints. And often from the employer's perspective, the employer becomes, or the prospective employer, I should say, becomes concerned if the job candidate is trying to negotiate on the restraints, because then the focus seems to be for the candidate on what's going to happen when they leave, rather than, you know, faithfully serving the employer's interests. So that can be an unsettling experience for an employer. So look, my general experience is that employees need to negotiate with care so that they don't jeopardise the offer if that's a concern to them. But look, sometimes those restraints can be negotiated at the time that you enter into the employment agreement. Be careful what you wish for though, because if, for example, there's a 12-month restraint and you negotiate it down to 6 months, and then when you leave, you want to argue that 6 months is the employer and possibly the court will say, well, hang on, you negotiated it to 6 months, presumably you were happy to sign on that basis. So sometimes you're just better off accepting the offer as it's made to you, and then navigating the legal issues when it comes to termination and those restraints being activated. But I think it's a truism that, you know, generally there is an inequality of bargaining power between an employer and an employee in most cases. And so that does mean that offers of employment tend to be put on a take it or leave it basis, including with respect to things such as restraints. And the employer is probably going to think to themselves, well, I don't want to have different forms of or lengths of restraint with different employees. They'd prefer there to be parity, like so everyone's on the same type of restraint. So that's another consideration from the employer's perspective.
Thank you very much, Adrian, and thank you everyone for your comments, your questions. That's certainly enriched the conversation that we've had. At this juncture, we are going to bid Adrian well and thank him for his time. So thanks, Adrian, for your advice, your experience. Yep.
You're welcome. Thanks very much, everyone.